Employment law is one of the most consequential areas of knowledge for any manager, and one of the most poorly understood. Most managers received no formal training in it. They learned on the job from colleagues who also learned on the job, often building a working understanding full of gaps, myths, and outdated information. And in a global workforce, where employees may be working across multiple jurisdictions with significantly different legal frameworks, the risk of that knowledge gap has never been higher. This video is not a substitute for legal advice. No video is. What it is an essential orientation to the principles and domains of employment law that every manager needs to understand to make decisions that are both legally sound and organizationally defensible. The first milestone is understanding the foundational categories of employment law that apply across most jurisdictions. Employment law operates across 5 primary domains. First, the employment contract, the legal relationship between employer and employee, which exists whether or not it is written and which creates mutual obligations from the moment employment begins. In most common law jurisdictions, an employment contract includes both express terms, explicitly agreed, and implied terms, which exist by operation of law, regardless of what the contract says. Second, discrimination and equal opportunity, protections against adverse treatment based on protected characteristics, including race, gender, age, disability, religion, national origin, and in many jurisdictions, sexual orientation, gender identity, and pregnancy. Anti-discrimination obligations apply not just to hiring, but to every term and condition of employment. Third, working conditions and wages, minimum wage requirements, overtime rules, working hour limitations, rest period obligations, and leave entitlements, all of which vary significantly by jurisdiction. Fourth, termination, the conditions under which employment may be ended, the notice or severance requirements associated with termination, and the protections against wrongful dismissal. Fifth, workplace safety, the legal obligations of employers to provide safe working environments, and the rights of employees to refuse unsafe work. The second milestone is jurisdiction awareness, the recognition that employment law is not uniform, and that global or multi-location organizations must understand the specific legal framework in each location where they operate. Several distinctions are particularly significant. The distinction between at-will employment, prevalent in the United States, where employment can generally be terminated at any time for any lawful reason, and just cause frameworks, common in most of Europe, Canada, Australia, and many other jurisdictions, where termination requires demonstrated justification. The distinction in contractor versus employee classification, which is treated differently across jurisdictions, and which carries significant legal and financial risk when misapplied. Workers classified as contractors who meet the legal test for employee status in their jurisdiction may entitle the engaging organization to substantial back pay, benefits, and penalties. The variation in protected characteristics. What is a legally protected characteristic in one country may not be in another, and what is required accommodation in one jurisdiction may be discretionary in another. The third milestone is the manager's day-to-day legal obligations, the practical translation of employment law principles into managerial behavior. 5 practices keep managers consistently on the right side of employment law. First, documentation. Consistent, contemporaneous documentation of performance issues, disciplinary actions, accommodation requests, and significant employment decisions creates the evidentiary record that protects both the organization and the manager in any subsequent dispute. Second, consistency. Applying policies, standards, and consequences consistently across employees who are in comparable situations is the most important safeguard against discrimination claims. Third, accommodation, understanding the obligation to provide reasonable accommodation for disability, religious practice, and other protected needs. And engaging in a genuine, documented accommodation process rather than assuming accommodation is impossible without exploring it. Fourth, consultation before action. Significant employment decisions, particularly terminations, demotions, and significant changes to terms and conditions, should be reviewed with HR and, where appropriate, legal counsel before implementation. Fifth, timely response to complaints. Employment law in most jurisdictions requires prompt, good faith response to employee complaints of discrimination, harassment, or safety concerns. Here is the trap. Managers who operate primarily from intuition and organizational culture rather than legal awareness are not just creating personal liability, they are creating organizational liability. The single most common response to employment law violations is not malice, it is ignorance. And ignorance in employment law is not a defense. Your go-to: identify the 3 jurisdictions in which your organization employs the most people. For each, identify the one employment law area where your current management practice is most likely to have gaps, whether in documentation, accommodation, or termination process. That is your highest priority legal risk management investment. Employment law and employment contracts work in tandem. The employment contracts video in this series covers the specific document architecture that operationalizes many of the legal obligations covered here. That is your next step. The employment law area that has generated the most significant legal and financial risk for organizations over the past decade is worker classification. The determination of whether an individual performing work for an organization should be classified as an employee or as an independent contractor. The financial stakes are significant. Organizations that misclassify employees as contractors may be liable for unpaid employment taxes, superannuation or pension contributions, minimum wage entitlements, overtime pay, and leave entitlements, potentially extending back years. The legal tests for worker classification vary by jurisdiction, but share common factors. The degree of control the organization exercises over how work is performed, whether the individual is integrated into the organization's regular operations, whether the individual bears commercial risk, and whether the individual provides services to multiple clients or works exclusively for one organization. Many contractor arrangements that feel contractually sound do not withstand the legal analysis applied by employment tribunals and tax authorities. The extension of anti-discrimination law to address unconscious bias represents another significant evolution in employment law obligations. While most jurisdictions do not yet explicitly codify unconscious bias as a legal category, courts and tribunals have increasingly held that employment decisions with statistically demonstrable disparate impact on protected groups require evidence of legitimate, non-discriminatory justification, even when discriminatory intent cannot be proven. This means that organizations whose hiring, promotion, and performance assessment processes produce systematically skewed outcomes for protected groups face potential discrimination claims, regardless of the subjective intent of the decision makers involved. The legal risk management implication is that organizations should audit their people processes for disparate impact, not just for deliberate discrimination, and address structural biases in their talent management systems before they generate legal exposure. Finally, the global minimum wage landscape is one of the most rapidly evolving areas of employment law compliance, with minimum wage rates in many jurisdictions adjusted annually, and with some jurisdictions, particularly in the United States, varying significantly between federal, state, and city levels. Organizations operating across multiple jurisdictions need to maintain current awareness of the applicable minimum wage in each location, and ensure that systems for salary review and adjustment keep pace with legislative changes. Non-compliance in this area is among the most audited and enforced aspects of employment law globally. Thanks for watching. If you found this useful, hit like and subscribe to our channel for more practical insights. And if you're ready to go further, check out the next video on your screen.